several interesting topics. I know that we have several members who are coming late, and I apologize to folks in the audience as well. I thought we were starting at 10, and so my apologies. My co-chair, Delegate Barve, and I are swap back and forth on meetings, so I will take the lead, I guess, on this one, and we will split duties. I guess let's go ahead and jump right into it. So the major subject today will be the Maryland's Public Information Act, the fees and the appeals process. And just to give context for folks who have any questions about this issue, the concern has arisen to this committee as to the process by which fees are determined across various jurisdictions and municipalities under the Public Information Act. And so our goal here today is to sort of gather information about how different levels of government and organizations of government come up with these fees, and see if there is any sort of standardizing process that may be possible that's not too burdensome on local jurisdictions or the state, but that is reasonable. So this is really a fact-gathering exercise today, and we look forward to the testimony from the various folks who will be joining us. So we will begin with Adam Snyder, who is Chief Counsel of the Opinions and Advice for the Office of the Attorney General.
There, it's on. Okay, the red stripe.
Transparency is our joint committee meeting being broadcast or transcribed or recorded today?
That is an excellent question. Yes, for those who may be in the audience virtually, we are being live streamed so that everybody is aware, recorded and live streamed on the House Ways and Means Committee stream on the website. So we should be, it is blinking on air, so we are in fact live and on air. Thank you.
All right, good morning, Chairman Barve, Chairman Ferguson, delegates. As the Chairman, pardon? And Senator. Oh, and Senator. As the Chairman described, I'm the Chief Counsel, Opinions and Advice Division of the Attorney General's Office, and in that capacity, I oversee the state's implementation of the Public Information Act. This morning, I'm going to spend about 10 to 15 minutes describing giving you an overview of the fee and appeal provisions of the Act, and if we have time, I'm available to answer any questions you may have about things that I'm hearing from my position as to how the PIA is being implemented. First, about fees. The Public Information Act allows the custodian of records for state agencies and local governments to charge, quote, a reasonable fee for the search for, preparation of, and reproduction of a public record, with the caveat that the first 2 hours involved in that process are free of charge. Now, that raises a few questions about what those terms mean. First, reasonable fee. The term reasonable fee is defined by statute to mean a fee bearing a reasonable relationship to the recovery of actual costs incurred by a governmental unit. Now, what that means depends on the activity that's involved in responding to a PIA request. And as I said earlier, the statute identifies 3 such categories of activities: the search for records, the preparation of records, and the reproduction of records. Now, the search involves finding the records within the agency's files in the first place. And that can be as easy as doing a computer search for emails or a network search for particular documents. It can also be as involved as doing a file-by-file search for particular responsive documents. So the difficulties involved in searching for records can vary dramatically from request to request. The second category of expenses involved is the preparation of a record. And typically what this involves is reviewing the document to determine which aspects of it can be provided under the Act. The Act, of course, has several specific exemptions from disclosure, and it's up to the agency to review those documents to determine whether the agency may permissibly disclose the records under the Act. That can also involve redacting. If a particular document is generally disclosable, but there are particular types of information in it that is exempt from disclosure, the agency has to take the time to identify those passages and redact them. The last category of expenses is the one that's perhaps more familiar to everyone, and that's the copying cost, the cost of reproducing the record. Typically, that's just a per-page copy charge, but under certain circumstances, the statute also allows for a reasonable fee for the making of or supervising the making of a copy of a record. So if you have particularly voluminous requests, the statute provides some ability for an agency to charge, for example, the labor that is involved to actually stand at the copier if it's going to take several hours to do that. And some agencies in their fee schedules actually provide for that expressly. Now, I want to talk about how these provisions get enacted or get implemented in practice. The cost for the first two categories of activities, the search and preparation, varies fairly widely across state agencies. Some agencies have in their regulations a flat per hour fee for performing that type of review, and that fee also varies amongst those agencies. For example, DHMH regulations have a $25 per hour fee. MHEC has a $20 per hour fee. The Motor Vehicle Administration has a $30 hour fee and a $250 an hour fee for computer programmers to write specific programs to generate reports in response to requests. Other agencies have fees broken out by how high up within the institution the person who is processing the request sits. So supervisory personnel get charged out at a higher rate than clerical personnel. The Department of the Environment regulations have a kind of a variegated fee structure along those lines. Other agencies still will look at the actual gross salary of the person who's involved in responding to the request, calculate that down to a per hour expense, and then charge at that rate. So it will differ from employee to employee within that agency. So there's like I said, a fair bit of range in how agencies approach that. There's also a fair bit of range in the per-page copying charge that agencies charge under the PIA, although it's perhaps not as broad. Probably about half of the agencies charge 25 cents per page, but it ranges from a low of, I think MVA charges only 3.5 cents per page for certain types of documents, to a high of 51 cents per page that the Board of Public Works charges. But there's agencies at pretty much every price point between those two. So it is spread out fairly broadly, although, like I said, probably the predominant fee is 25 cents per page. If, however, well, sometimes an agency will get a request for documents that they can't copy in-house. One example would be large, oversized property plats. In that instance, agencies have statutory authority to charge what the actual cost is for providing the facilities to copy that document. So if they sent it out to a Kinko's that charges $5 a page, that's what the agency would charge. There are provisions in the Act also to allow for the waiver of fees. And fee waivers are available if the applicant requests a fee waiver and the agency or the custodian, after considering the ability of the applicant to pay the fee and other relevant factors, determines that waiver of a fee would be in the public interest. Now, the statute specifically says that the agency has to consider the applicant's ability to pay, but it also says that the agency consider other relevant factors. So the fact that an applicant can or cannot pay is not necessarily dispositive. The test here is whether a fee waiver is in the public interest. And the types of factors that the courts tend to evaluate here is the request, does the request have significance really only for the requester or a very narrow group of people, or does it have a wider significance? The wider the significance, the more likely that the fee waiver would be in a public interest. Also, does the requester have the means to disseminate his or her message to the public? So, for example, a prison inmate may be less likely to get a fee waiver despite their, fairly obvious inability to pay, because they tend to be seeking documents for their own post-conviction proceedings and really don't have the means to broadcast a larger message that would kind of implicate the public interest provisions of the Public Information Act. Conversely, a newspaper, which very much has the ability to disseminate a message, is typically the type of requester who's in a good position to obtain a fee waiver. Now, before I move on to appeals, I do want to talk a little bit about how I see fees working in practice and kind of what I see as the policy justifications that you will consider in your deliberations on what to do about fees. The importance, there's two parts of the fee provisions of the Act that are important to consider here. One is that it encourages requesters to think about what materials they're interested in and to request just those materials rather than the kind of catch-all requests that you tend to see in, for example, in litigation. Give me all documents relating to the pollution of the Chesapeake Bay is going to reveal an astonishing, or encompass an astonishing number of documents and generate a very high fee request. The fact that that request will generate a fee that the applicant will be responsible for encourages them to sit down with the agency. Again, perhaps the requester doesn't really know how to describe what it is they're after. But the fee provision encourages that requester to begin that dialogue with the agency and find a way of crafting a request that gets at the stuff that they're really interested in with the least inconvenience to the agency and the least expense to the applicant. The other policy aspect of this is who should be bearing the cost of submitting PIA requests. Whenever someone submits a request and the agency has to divert resources to fulfilling that request, that means that the agency's other customers or regulated community, at least theoretically, should experience a drop in the services that they receive because folks will be fulfilling PIA requests. Now, there's nothing wrong with that. The Public Information Act is a law just as the other laws that agencies enact. But the PIA fee provisions and the waiver provisions are kind of based on the policy choice that if a request is truly in the public interest, well, then you waive the fee and the whole public pays for it. If, however, the request is more of a private matter or more narrow with a more limited significance, well, in that instance, the public shouldn't be footing the cost of responding to that request. The requester should. So those are some of the policy considerations that are at play in how the fee provisions work. I want to move on to appeals because I'm tasked with covering that as well, but I'm happy to answer questions at the end about fees as well. The appeal provisions are basically twofold. For state agencies that are subject to the state APA, requesters can request an administrative appeal to the agency, which tends to get routed to the Office of Administrative Hearings, but doesn't necessarily have to be, to determine whether the request is or the denial of the request is in accordance with the law. That provision doesn't apply, though, to local governments who are not subject to the APA. The judicial review provisions, however, are applicable to all governmental entities that are subject to the Public Information Act. And requesters who have been denied inspection of a record have the opportunity to petition for judicial review in the circuit court in the jurisdiction where they're located. And they have no need to take advantage of the administrative appeal provisions before they do so. There's no exhaustion requirement. So if you're requesting records from the Department of the Environment, a state agency, you don't have to do the administrative agency approach first. You can go straight to court. Local government request, you go straight to court anyway. Appeals are to be expedited in every way. The agency has the burden to support its denial. The court, if it determines that materials were improperly withheld, may order that documents be turned over, may impose counsel fees and other litigation costs. The court may also, in certain circumstances, award damages for instances where the agency, by clear and convincing evidence, knowingly and willfully refuses to turn over documents that it is obligated to turn over. I am not familiar myself with any instance in which those provisions have been invoked or applied by a court. That's not to say that it hasn't happened. It could have happened. It's just not something that rose to the level of an appellate decision. Mr. John Garius, who will be speaking later, stumbled to his disadvantage on a little ambiguity in the statute, that ambiguity being it provides for judicial review for the denial of the inspection of a record and doesn't say anything about the denial of copies. And Mr. John Garius, Mr. John Garius will, I'm sure, talk to you about his personal experience with that provision. We had noticed that ambiguity in the statute and had provided in the Attorney General's Office Maryland Public Information Act manual the prediction that a reviewing court would likely construe the provision as applying to the provision of copies as well, since the statute provides for both the right of inspection and a right of copies. Turns out we were wrong in that prediction, at least in Mr. John Garius's case. But I'll defer to Mr. John Garius to describe the circumstances surrounding his situation. That's my kind of prepared marks. I can share with you some of the things I'm hearing about how the PIA is being implemented, or I'm open to answering any questions you will have, or if you want to move along, I'm happy to stand down.
If you wouldn't mind, just some of the thoughts of things that you hear from agencies and from the public.
One of the things I've heard is the circumstance where local governments, typically towns and municipalities that are not have a large enough town government to justify the expense of in-house counsel, and so they have an outside town attorney who may bill them at an hourly rate. And when they get a PIA request that involves difficult determinations as to what is and is not disclosable, they will ask their outside counsel to review that, review that process, and that outside counsel may charge them at their going rate that they charge the town at. It might be $100, $200 an hour, So a PIA requester who believes that maybe it's not a particularly complicated request gets back a bill for $800 and smells a rat and thinks that the locality is trying to run up the cost of responding. That's not necessarily the case, because sometimes attorney review about how different exemptions apply is necessary in order for the agencies to be sure that they're faithfully complying with the law. And if the statute provides that they're allowed to recover their actual costs and their only means of getting legal advice is by sending it to outside counsel, the town's not doing anything wrong, but at the same time, the requester feels that they're being deliberately frustrated in their efforts to get at public records. So that's a tension I see in how the Act is being implemented. And again, I don't think either side is doing anything wrong there. It's just kind of the nature of the beast. Let's see. Another thing that you might be hearing is how the state is responding to PIA requests. And I want to share with you an example that I think made it into the news briefly a couple months ago about a PIA request from a news agency seeking all Public Information Act requests submitted to the Office of the Attorney General since, I think it was 2009, and any responses thereto. So a PIA request for PIA requests and responses thereto. So we get that request, and I go out to all the different divisions of the Attorney General's office and say, well, let me know how much, do you have any, how expensive would, how much labor will be involved in finding out this information? And what I heard is that, well, some of these divisions have tracking databases that would allow them to identify specific requests. They would then have to go poll those particular requests, and there'd be an expense involved in that, but it would allow for a fairly targeted search. But a lot of requests come within the scope of ongoing litigation. And in that instance, these requests, though they might say that they're a PIA request, don't get tracked as a PIA request. The documents are provided in the course of the litigation, and the request is just stuck in the agency's file related to that particular case without any kind of tracking record. So I corresponded with the requester that if you really wanted to get all of this, it's going to be a very, very high cost, because we're going to have to do a file-by-file search of those non-tracked requests for all these different agencies and kind of explain to them the ins and outs of everything. So that began this dialogue that ultimately got us down to the point where the expense was going to be about $150, because really he was only interested in requests that were coming in to, if you will, the Attorney General himself or the headquarters of the Attorney General's office, and not the particular divisions. I say this seemingly mundane story, a success story, I think, in how the PIA should work, made it into the news because the requester eventually did a story about how the PIA Act is not working because he went to the Attorney General's office to get public records and was told that it was going to cost many thousands of dollars to get his records. Now, that's true. That's what he was told right off the bat because his request was so broad. But once we engaged in the dialogue and kind of figured out what is the best way to get at what he really wanted to get, we got it down to $150. And generally speaking, the fee provision allows for that dialogue, and in my mind is kind of the way the statute most effectively works, is if the requester and the agency can work together and try to figure out how to get the public the documents that they want in the most efficient manner.
Delegate Barve. There we go.
You might not be able to answer this question, so let me know if you can't. What proportion of the time do you think, when these requests are made, are the requested files in digital form?
I certainly can't put a hard number on that.
Is it a fantastically small percentage?
No.
No? Okay.
No, I mean, if only because a large chunk of the responsive documents are going to consist of emails.
Okay.
Which can be, electronically searched and electronically provided under, the right circumstances. Don't ask me how it's done so much, but it can be done. And also, the prevalence of people beginning to keep files electronically, so they'll have a finished letter that otherwise might have been in a paper file. A lot of those now get PDF'd and will sit in a computer file. So you're seeing it more and more that that percentage grows over time.
Okay, thank you.
Questions from the committee? I have a couple of questions. Thank you. This was a very, very helpful presentation. The fee structure, it also varies pretty dramatically across local municipalities, counties and municipalities, as much as it varies across agencies. Is that fair?
I don't know, just because I don't implement that portion of it, and it's easy enough to search through Kumar and find what the range is. I haven't done that with respect to local government fees.
And the requirement that, or the act of putting it in regulation that some agents, so I guess DMV or MVA and DHMH, that was by choice. It's not required that their fee structure be illustrated through regulation.
Yeah, I don't believe that's statutorily required, but most agencies do that.
Okay. The process for waivers, do any agencies have that listed in regulation, these factors, or is that just something each agency determines on their own?
The fee waiver provision?
The fee waiver.
I think the vast majority, if not all, of the state agencies have provisions that fairly closely follow the statute that say, we consider the ability of the applicant to pay the fee and other relevant factors, and will issue a fee waiver if it's in the public interest. I'm not aware specifically of any agency that has tried to break that out in greater detail, in part because, well, I mean, the courts apply their own set of standards. An agency spelling it out may get some deference on that point, but I think courts wouldn't be shy about judging for themselves what public interest is, given that it's a flexible enough statutory standard.
That makes sense. Thank you. I have two more questions. Mm-hmm. If an agency makes data regularly available, just as a practice of its cultural habit, say through state stat, or can the agency fulfill its obligations under the PIA by pointing the requester to where that data may be available and accumulated on their own?
Excellent question. I believe so, but there's not a lot to go on to support that. There are provisions of the Public Information Act that encourage agencies to make frequently requested materials publicly available. It doesn't use the word, I don't believe, website, but that's kind of what the implication is. So it would seem to me that an agency that abides by that statutory encouragement and puts these records available on their website should be able to respond to a request for that same information on a diskette by saying it's available on the website. Now, that said, you could conceivably have requesters still in this day and age who do not have an internet connection and live far from a public library and whatnot. So you can't rule out the possibility that standing on that principle wouldn't mean that a particular requester here or there may not be able to gain access to the information that they seek, but it's given the prevalence of internet, I would think agencies I think a requester would have to make some kind of a showing of inability to use the website before they'd be able to challenge an agency that is trying to be proactive and put these things on their website.
Last question has to do with the appeal process. In your experience, have you found that agencies that use the Office of Administrative Hearings have a better or worse relationship with PIA requesters? Has that been a positive experience for most agencies to use OAH, or a burdensome negative experience?
I don't really have any specific experience with respect to particular administrative proceedings involving the PIA. I can tell you more generally, the OAH, generally speaking, is, I think, preferred by members of the public, whether they're challenging a permit issuance or something like that, because the OAH has that separation from the agency. Mm-hmm. And typically, the criticism of the process that you hear is not so much that it's going to the OAH, but that at the end of the day, the OAH only renders a proposed decision, mm-hmm. and it comes back to the agency for a final decision. That last step is what people more frequently complain about, not so much that it goes to the OAH.
Yes, Doug Moore.
Thank you. Did I gather from what you said that there's some differences between agencies in fees, that some have some of these rules and regulations and some don't, and maybe some other policies? Is that the case?
Well, yes.
Okay.
Not all of the instrumentalities of the state that are subject to the Public Information Act have regulations addressing how they're going to implement the Act. The vast majority do, and they have fee provisions in them that cover this ground.
Well, let me ask it this way then. Mm-hmm. Does it make sense, with possible some exceptions here and there that could be justified, that there be consistency across state agencies for this purpose?
With respect to the fees charged?
With respect to policies, fees, although there may be some exceptions because of unique circumstances of privacy or whatever. But part of the theory here, I think, would be that if a citizen contacts one agency, they know what's going on. If they contact another one, they should have the same set of circumstances, not have to learn that, well, this one's in regulation, this one charges 20 cents, this one charges 25 cents a copy. Would it make sense to do that?
I think with the caveat that you've provided that there be flexibility to tailor it in particular circumstances, yeah, I think there would be some value to have that kind of consistency.
So is this the kind of thing that you could audit the agencies and kind of stagger out their common areas and the few areas that might be different, and then present a policy option, whether that's every agency is just going to do it by executive push or whether we have to do legislation that would say, for the common stuff, you're going to have the same set of rules everywhere, including some of the things that the chairman and the other two chairmen asked. Yeah, and the fee structure should be the same too. And then if there's certain unique circumstances like trying to send out a map or judicial issues, then you could have some variance. Does that make sense?
It does, but I do want to. I think it's. I can't rule out the possibility that even the per-page copying fee may have good reasons for varying from agency to agency. For example, MVA has a very low per-page copying fee, and it may be because they've got lots and lots of copiers. They deal with document requests all the time, and they've got it down to a science, as odd as that might sound. Other agencies may not. And perhaps a local government may only have one copier that
leave local government out of it for a moment.
Okay.
We don't really
right. Well, you might have a board or a commission that falls roughly into that same category. But theoretically speaking, yeah, it would seem to me that you should be able to achieve somewhat more uniformity on these types of topics.
Maybe that's another thing we can explore. Because I think from the point of view of the general public, whatever differences we see, they see government as one large amorphous, entity, and it ought to be as consistent as possible. We get requests, about immigration issues. We're not federal legislators. We all get communications about a stop sign. We're not local legislators, but they see us as part of government, and they expect a response that's appropriate and directive. But you can't just say to people, that's not my area. I think the same thing here. The more that it's made consistent, the easier it will be. And if there's a mechanism that you can initiate by surveying the agencies and then finding the common ground stuff and then allow some variance, I think that would be helpful.
Well, we do have, the Attorney General's office has on its website model regulations for implementing the Public Information Act that include this 25% per page fee that most agencies appear to have adopted. And when I scroll through the different Kumar provisions, a lot of them bear a lot of resemblance to the model regulations on our website. So there's some standardization, but I'm sure there'll be opportunities for a lot more.
Thank you very much. I think with that, we will move to the next panel. Thank you. That was very, very helpful. So we have two panels today for this section.